Hello everyone, today in this video we will discuss about ODI compliances. So starting with the meaning of ODI. Investment made outside the territory of a country by way of contribution to capital, subscription to memorandum of foreign entity and acquisition of shares by way of market purchase, private placement or through the exchange in a joint venture or wholly owned subsidiary is termed as overseas direct investment. So before moving to the eligibility and the procedure of overseas direct investment, it is important to know the meaning of certain terms. First one is authorized dealer bank. So ODI can be made only through authorized dealer banks that are registered with RBI. The Indian party or the resident individuals are required to route all their transactions in respect of a particular overseas joint venture or a wholly owned subsidiary only through a particular authorized dealer bank. Now, who is an Indian party? Indian party is a company incorporated in India or a body created under an act of parliament or a partnership firm registered under the Indian Partnership Act 1932 or a limited liability partnership incorporated under the LLP Act 2008. So, where more than one such company, body or entity makes investment in the foreign joint venture or wholly owned subsidiary, such combination will also form an Indian party. Now, what does joint venture and wholly owned subsidiary means? So, joint venture or a wholly owned subsidiary is a foreign entity formed, registered or incorporated in accordance with the laws and regulations of the host country in which the Indian party or the resident Indian makes a direct investment. So now, having discussed about the meaning of overseas direct investment, we now come to the procedure for making ODI. So basically there are two routes of making overseas direct investment. First one is under automatic route. So under the automatic route, an Indian party does not require any prior approval from the Reserve Bank for making overseas direct investment in a joint venture or a wholly owned subsidiary abroad. Indian parties or resident individuals are required to follow certain steps for making ODI. Firstly, the applicant is required to file Form ODI Part 1 and get the same certified from a statutory auditor. It is important to note that the certification from the statutory auditor is not required in case of resident individuals. Next is the submission of Form A2 of the respective AD bank along with the above mentioned Form ODI Part 1. So the Part 1 contains the details of the joint venture or the wholly owned subsidiary in which the investment is to be made, along with the detail of the Indian parties or the resident individual and the remittance and other financial commitment of the overseas entity. Subsequent remittances under the automatic route and the remittances under the approval route should be made only after the receipt of auto-generated email from RBI confirming the UIN. Now for valuation of shares, it is pertinent to note that in case of partial or full investment in existing foreign company, where the investment is more than $5 million, or in case investment by way of swap of shares, valuation is required to be undertaken by Category 1 merchant banker which is registered with SEBI, or by an investment banker or a merchant banker registered with the appropriate authority in the host country. In all other cases, the said valuation shall be done by a chartered accountant or a certified public accountant. So next route of ODI is under approval route. The applicant should approach their designated authorized dealer bank with the proposal which shall be submitted to Reserve Bank after due scrutiny and with the specific recommendation of the designated AD bank along with supporting documents. For approval by Reserve Bank, some documents need to be submitted along with the Section D and Section E of Form ODI. So the documents are, first of all, a letter from the designated authorized dealer bank in a sealed cover mentioning the details of the transaction number generated by the ODI application, brief details of the Indian entity, brief details of the overseas entity, background of the proposal if any, brief detail of the transaction to be undertaken by the applicant entity, reasons for seeking approval mentioning the extent of FEMA regulation, observation of the designated AD banks with respect to the following like the prima facie viability of the joint venture or the wholly owned subsidiary which is situated outside India, the contribution to external trade and other benefits which will accrue to India through such investment, financial position and business track record of the investment party and the foreign entity, expertise and experience of the Indian party in the same and related line of activity of the joint venture and the wholly owned subsidiary situated outside India, and lastly the recommendation of the designated AD bank. Next document is a letter from the Indian party addressed to the designated AD bank. Then comes the board resolution authorizing the proposed investment to be made abroad. After this is the diagrammatic representation of the organizational structure indicating all the subsidiaries of the Indian party horizontally and vertically with their stake and status. After that comes the incorporation certificate and the valuation certificate for the overseas entity. Then any other relevant documents that shall be properly numbered, indexed and flagged. Lastly, we will discuss about the post-investment compliances. So Indian parties are required to file two forms with RBI every year for ODI investment. First one is the foreign assets and liabilities which shall be filed on and before July 15 of the relevant financial year. And the next one is the annual performance report which is to be made in form ODI part 2 and on and before 31st December for ODI of preceding financial year through the AD Bank. Also, the resident individuals are required to file APR form every year, but they are not required to file FLA form. On the other hand, the Indian parties are also required to submit the share certificate of its investment with designated AD Bank within 6 months of investment. So this was all about ODI compliances. For more details, contact Rajput Jain and Associate, or you can also visit our website carajput.com. Thank you.